Hi everyone, welcome. My name is Kristen Begarius and I'll be your host for today's event, the L-1 Visa, Leveraging Your Organization's International Talent. In today's session, we'll discuss how to find the right talent for hard-to-fill executive, manager, and specialized roles using your company's current pool of international employees. First, I'd like to go over a few housekeeping items. This session is being recorded, and we'll be sure to send you the recorded session for your reference or to share with others in your organization. The presentation is going to last for about 40-45 minutes with a lot of time left for question and answers throughout the presentation. To ask a question, please use the question function on the right-hand side of the webinar screen or use the hashtag #LVisaMasters via Twitter. We will be asking the audience to answer a few polling questions throughout the session to ensure our discussion meets your needs. So with that, I'd like to introduce our speaker today, Karen Gillespie, a retained attorney who has built and submitted hundreds of non-immigrant and immigrant work visas. She has extensive experience handling VEHLO and TN visa cases, employment-based green cards, and USCIS requests for evidence. And with that, I will turn it over to Karen.
Thank you very much for the kind introduction. So today we are going to be talking about the L visa. And the L visa, as Kristen said, is a nimble tool for global mobility, but it can be laborious in document production and corporate relationship documentation as well. It's a very fact-specific visa type where templates really can only get you so far, and that's because when it comes to your company's specialized knowledge or your company's managerial tiers, organizational charts, those are going to be specific to your company. It's not one size fits all, and that's precisely the point of the L visa, is that because your company has its own procedures, its own product, and its own culture, sometimes the best choice is to move people from one entity to another as opposed to seeking candidates from outside your own international pool. We're going to be doing a poll really quick, and so we're going to do a couple polls throughout this process, and we'll be announcing to you the results of the polls as they go on. Crystal will be jumping in to let us know what the results of those were. The first poll we're asking is how many L visas has your company sponsored? So the L visa has pros and cons. Pros, as I said, you're able to move talent within your organization. It can be a much more seamless transfer than if you're acclimating someone to your company as opposed to simply acclimating someone to a new position or perhaps a new post. The L visa is dual intent, so if you're looking for a long-term work solution for someone, the green card is a very seamless transition from the L visa going into permanent sponsorship. A big one, too, is that spouses of L visa holders can get work authorization. That can be huge for a family. It's a lot to ask a family to survive on only one income, and the ability to move talent but let them know that their spouse will be able to work in the U.S. as well can be a great bargaining chip for you as a company. Due to the cons, there's a very high RFE rate, and RFE, for those of you who are unfamiliar, is a request for further evidence, where the USCIS is basically letting you know, we don't think you have given us enough evidence. The goal, of course, is always to provide evidence as needed to avoid those, but as we'll hear throughout this target, sometimes what the USCI wants to get from you is a bit of a moving target, and there is a very high RFE rate for L cases, especially for L1B specialized knowledge. Additionally, with an L1 case, when you move through the green card process, those of you who are familiar with the H-1B know that at a certain stage of the green card process, you can get something called an I-140 and get unlimited renewals of your H-1B. No such regulations exist for the L visa. So therefore, if you have candidates who are from China or from India and who might be looking at a very long wait to get a green card, the L visa is probably not going to be a long enough validity period to move them straight from L into the green card. So sometimes you're going to have a stopgap of moving them into H in the meantime, but something to think about when you're thinking about long-term solutions for your company.
Yeah, and Sharon, I'll just give a quick update on that poll. I think we have a really good and diverse audience here that's going to get a lot out of this. So we had about 35% who have never sponsored an L visa, about 34% who have done 1 to 5, 13% of you have done 6 to 10, and about 18% have done 11 or more. So we've got some really good high-level information here, and we're going to dive deep into some of this stuff for some of you who may not be as familiar with the L visa.
Great. Thank you, Kristen, and thank you, everyone, for responding. Our agenda today is to do a high-level overview of both the L1A and the L1B, a glimpse into what it would mean to open a new office inside the United States leveraging the L visa, something called blanket L certification, which can ease the document production requirements for your company and offer a bit more of a seamless L visa process. We'll go into more specifics about what in particular needs to be in a petition in order to be successful. And then finally, as Kristen said, we're going to leave some time for questions at the end, so please do feel free to continue submitting those as we go throughout the webinar today. The L1 visa, the first subcategory is L1A. L1A applies to executives and managers. An executive is someone who, as you would obviously expect, makes high-level policy decisions for the company, makes high-level decisions as to hiring and firing, is making overall plans for the company, and isn't worried about, maybe even one department. They're a bird's-eye view of the company itself. Importantly, the majority of their time must be spent in high-level management, not doing hands-on work. So it can be actually kind of difficult for a very small company to move an executive if your company has everyone as sort of a jack of all trades, where maybe your CFO is also the entire accounting department, has no one underneath of them, which of course doesn't happen very often if you have the corporate relationship for an L case. But as a warning, if your executives don't merely execute policy, but do a lot of hands-on work, you're going to have more of an uphill struggle in classifying them as a traditional L1A executive. On the other hand, a manager, there's a little bit more leeway, but you'll be asked to submit more evidence as to their managerial capacity. There are two different kinds of managers, according to the USCIS. One is a people manager. That is your more straightforward, tangible, boss-supervisee relationship. Again, the employee must spend the majority of their time doing management duties. There is more room for them to do hands-on work. So, for instance, if you had maybe the team lead in a software department who has 10 people underneath of him or her, and they do spend a lot of their time assigning tasks, reviewing the work of others, but they still maybe develop code as well. That doesn't preclude them from being a manager, but you will have to show the USCIS that the bulk of what they do is management. So again, you can't really just do it all yourself. They have to have some direction of others. If they are not a direct manager of people, they can qualify as what's called a functional manager. Functional manager is someone in your company that oversees something that is a quote-unquote essential function of your business. HR is kind of a good example to wrap your mind around what that would mean. Someone who is maybe the head of HR doesn't have any direct reports underneath of them, but they might be guiding the work of a lot of different people within your company. They are not necessarily sitting down at their desk typing reports every day, but they are, directing the work of maybe the interplay between accounting and between the exec team. So you are a channel for an essential function. That person can qualify. I will say, functional manager does require even more evidence to prove to the USCIS that what this person does is indeed essential to your business. It's not tangential. It is a core function of what you do. And that, again, they manage, that they are not boots on the ground, getting their hands dirty every day, but rather have management functions. That can be difficult to show. Sometimes it becomes a little more ethereal. What do you use? And in a bit, I will get into what the good evidence is. In fact, I'll just dive in now. One of the best ones is an organizational chart. it's very persuasive to the USCIS to give them a visual of here's what this person does, here's who they direct, whether or not they are direct reports, that this is who they're overseeing. Of course, for an executive, you already have half the battle won if you're trying to do a case for the person that is the CEO. There's already a per se suggestion this person's an executive, it's in their title. But if you have someone who's maybe the director of North American sales, you will have an organizational chart that is apparent that this person manages others. Of course, an organizational chart is what they call a self-serving document. I can make a line and block chart today that says I manage the White House and submit it to the USCIS and there's no proof behind it, and I doubt they would believe me. But you can include other tangible items. One thing you can do is submit the resumes and redacted, if you like, paychecks of other employees who the person sponsors. So then you're backing up that organizational chart with tangible evidence that those people actually work for your company and they're in the roles that you have assigned them on the organizational chart. Additional pieces of evidence could be performance reviews where the manager's name is listed as the reviewer. You could have reports where they are listed as the creator or the recipient of reports by subordinates, contracts signed by the person as the company's authorized signatory. So again, you can see there is no one-size-fits-all. It depends on what that person does. It depends on your company as to how much weight that person has within your company. So it can be difficult when you're first establishing what kind of documents your company is going to provide moving forward with an L visa program. And the first one's usually the hardest because your attorney is going to have to wrap his or her head around what you do. But I have found that once you do one L with a company and you both realize what you need from each other, it does get easier. So please don't be disheartened on your first L. And if it continues to be a struggle, maybe everyone needs to sit down and talk again about what you need from each other. So another aspect of being an L visa is that the employee has to have worked for 12 continuous months for a related foreign entity. I'll talk a little bit more about what that relationship between the entities means, but a common question is, what does that 12 months mean? Can there be gaps in it? In terms of employment, there cannot be. So if the person leaves the company after 6 months and comes back, they are essentially starting over that 12 months. However, they can travel to the U.S., and that doesn't necessarily remove time from that 12 months. It merely has to be subtracted out. So if you have someone who's traveling back and forth to the United States already for business meetings, that's not ruining their chances as an L-1, but you do have to calculate that time out to make sure you still have a full continuous 12 months of employment within the last 3 years at the time of the first application. L-1A visas get a total of 7 years. The initial application will be 3, and then there are ability to get 2 2-year extensions. You can also recapture any amount of time that the person spent outside the United States and tack that on at the end. As I mentioned, they're dual intent, meaning that there's a pretty seamless transition into a green card. And for L-1A executives, it's a pretty seamless transition into an EB-1 green card. If you attended our green card webinar, you might be familiar with that. It is an EB-1 multinational manager or executive. That's something to think about too if you are transferring an executive. The spouse can work. There's also something I want to make people aware of called inter L-1 employment. That means that the employee is spending less than 6 months of the year inside the United States and is still maintaining their residence outside the United States. If that happens, they're what is called intermittent, and that 7-year max out no longer applies to the employee. They are considered not to be a full-time employee inside the U.S., and your company is allowed to have the flexibility to have that person move in and out of the U.S., working while they're here, but not necessarily continuously residing here. That can also be a great solution if you have a company where employees need to travel to the U.S., and while they're here they need to work, but they're not here all the time. Intermittent can be a good way to avoid having to worry about maxing out, but still have the flexibility that an L visa allows. We're going to do another poll, and we're going to ask everyone if you think, for those of you who have done L's before, do you think that the L visa process is getting more difficult? And I suppose we mean in terms of applying to the government, not necessarily your personal vexation with your current provider or your current employees. So the L-1B visa is not managerial or executive. Instead, it is for employees who have, quote unquote, specialized knowledge. And what is specialized knowledge? It is a very gray subject area. I'm going to dive in a little bit deeper to it in a moment, but suffice it to say, specialized knowledge means it's something that is difficult to obtain, probably unique to your company, and you're basically letting the CIS know it's more trouble than it's worth to train someone new than it is to move this person. That's kind of the gist of it. There are other considerations I'll talk about in a minute, but that's kind of like, that's the way I try to let clients think about it, is you need to prove to the CIS that your company invested some time and experience in this person, and what they know truly is special. It's important to remember that the U.S. role has to require specialized knowledge. The employee could be the foremost expert on your company's online platform. They created it, they know every inch of it, no one else knows what they know. They are the cream of the crop, specialized. But if you're moving them to a U.S. position that doesn't require that knowledge, your petition will fail. And it's important not to forget to emphasize that in a petition, to say, yes, this person has it, and yes, they will be using it. Because if you forget to tell the USCIS how they're going to use it, you're probably going to get an RFE. And if you can't articulate to them how they're going to be using their specialized knowledge, your petition will ultimately be denied. And that is something I've seen more and more recently as a trend, is the CIS picking apart the assertions that the person will be using that specialized knowledge inside the United States. Should we have our surveyors?
Yeah, absolutely. So really interesting here, and I think you're going to probably be in line with this, but about 75% of our audience said that yes, they believe that the L1 application process is getting more difficult, and about 25% said no. So pretty overwhelming majority there.
Well, you 25%, send me an email and let me know your secrets, because I do agree with the 75% that it has been getting more difficult. A huge, my theory, if you'll indulge me for a moment, is as the H-1B cap has become more and more constricted with a larger pool of people applying, roles that would have traditionally been H-1B, companies are now trying to kind of shoehorn into an L case. And it's not always a great fit. Sometimes you have good luck. Sometimes you can be creative, and sometimes that creativity can backfire on you. But because more companies are having to rely on L's where an H might have been a better fit, I think the USCIS is tired of seeing poor applications, and as a result has become more and more picky and more likely to issue RFEs on cases they find to be deficient. And rightfully so, it is their job to ferret out cases that are not appropriate, but unfortunately it means as a company who has a good case, you need to make sure you have all your ducks in a row, because there's no more wiggle room. You need to present basically a perfect case to them, or it's going to get an RFE, and it may or may not get denied if you cannot supply what they want to hear from you. So going back to the requirements for L-1B, there's also the 12 months requirement with the foreign related entity, and as promised, I'm going to discuss a little bit about what related means. So an entity, both of the foreign entity and the U.S. entity must have been open and operating for at least 1 year. Of course, the foreign entity is going to have been open for a year, because the employee has to have worked there for a year. It's not possible if the foreign entity has only been open 6 months. It just wouldn't work. The U.S. company could be open for less than that, but you'll be looking at that new office L-1 visa, and I'm going to discuss that in detail in a bit. But to do a traditional L-1A or an L-1B, you have to prove both companies have been operating. How do you show that? Certificate of formation is a good one. If you have tax returns or financial statements, if you don't have those things, if your company is relatively new, you haven't filed your taxes yet, but you've been open a year, one thing to do is supply invoices from customers showing on, engaging in active commerce for a year. In terms of relationship, it can be parent, subsidiary, affiliate, or joint venture. The real crux is just, it's sort of like middle school math, show your work. The USCIS is not going to make leaps in your favor. They are going to ask you to spell it out for them. You have to clearly demonstrate a relationship. I recently had a client who suggested to me that because the two entities had the same name, of course they were related. And as much as I would have liked to test out that argument with the United States government, I don't think it was going to work. So we ended up submitting more evidence than merely their names. But that is, misconceptions in, the U.S. government is not going to give you any favors, and they are not going to cut you any slack. You need to show them, and the conflict can be as a company being private about the relationship within your entities, and I fully understand that and I respect it, but the United States government doesn't care. And if you won an L visa, you got to play ball. So sometimes as a company, it can seem like an attorney is being nitpicky or demanding a lot of documentation from you. I assure you, my colleagues and I do the same, and it is to protect your bottom line, to not waste money on filing fees and time for your employees. RFEs typically take a long time to respond to, and they're going to ask you for a lot of documents that you probably didn't want to provide. And so sometimes, that old saying, an ounce of prevention is worth a pound of cure. And nothing is more true in that regard with L visas than corporate documentation. Provided up front, and the United States government is much more inclined to grant your visa than if they think you're trying to hide the 8-ball as to how your companies are related. So as I said, what is specialized knowledge? I wish I had an easy answer for you. If I did, we wouldn't be doing this webinar, and I probably wouldn't have a job. So in some ways, I guess I'm grateful. In other ways, it's a real headache for everyone. There are two levels of specialized knowledge. The first is special, and that just means distinct or uncommon in the industry or the organization. Now, when you hear that "or," take it with a grain of salt. While all of the regulations and all of the memos the U.S. government puts out say "or," frankly, it should say "and," because I have yet to see a case approved that relied merely on industry knowledge. The government has said over and over again that they don't necessarily require proprietary knowledge of your company. That's the strongest case, though. If you have a patent and that person was on it, that's a slam dunk specialized knowledge case. If you have a complex software product, knowledge of it alone is not going to prove specialized knowledge. And if you have the foremost expert on, Microsoft Word, they might be the best, but that alone, industry knowledge, is not going to, and Microsoft Word is, of course, a very silly example, but even a very industry-specific software, someone who's maybe the expert or who wrote it and your company uses it, still might not be enough for specialized knowledge. Advanced knowledge is sort of the other tier of L-1B, and the distinction between them, there is no difference in time you're allowed in the U.S. It's merely different ways to argue to the United States government that this person has that. It's advanced knowledge. And the definitions can sound very similar because they are, and that means stuff that's not common in the industry and is greatly developed compared to other employees. So it's just that greatly developed one where you're talking about maybe this person's been with your company for 15 years. That you can't hire someone in the U.S. to do that job. They have the experience. You could hire someone in the U.S., but you would be able to fill the role for 15 years. So that's a good argument. But there is a presumption from the USCIS that it takes at least a year to gain specialized knowledge. The regulations then say the person must have been in their specialized knowledge role for those 12 months. So in theory, the employee must have worked for 2 years for your company outside the United States. 1 year gaining the specialized knowledge, 1 year applying it. I have had success with cases where an employee has worked less than 24 months at the foreign entity, but that is when there is very strong evidence of the training logs that are specific to the company's technology. Letters from a manager abroad explaining why this person has stood out, performance reviews where they're getting 5 stars on everything. Very strong cases. But generally, the presumption is L-1B is for employees that are so invaluable that you can't train them in the U.S. And a lot of times the U.S. government views someone who's been there for less than 2 years as very trainable. You could still hire someone in the U.S., and yes, there'd be a little bit of annoyance on the part of the company, but not indispensable. So the less time an employee has worked for you abroad, the more documentation you're going to have to prove, and the less likely it is the government's just going to sort of take it at face value. Whereas if you have someone who's worked there for 20 years, then part of every decision in the company, that is a great case. Of course, the presumption is that they do have specialized knowledge of your company and what you do that can't be gained. Another sort of, issue is that if you train all of your employees with the same rigor, you will then again run into the difficulty of the person's not actually specialized. You do this with everyone. So there's a catch-22 in having training logs that show that everyone goes through this regular training at 6 months, they all do it. Well, then how is this person special? You do that for everyone. You would do that for the person you hired in Alabama the same way you would for someone you hired in Albania. So again, L-1B, that's why it's so difficult for attorneys to pin down what is specialized knowledge. My first question is, what does your company do, and how do you train people when you hire them? But the U.S. government did issue a memo back in 2015 where they put out a list of 6 factors which they back and forth, up and down, said are not exhaustive and are not complete, but it's a totality of evidence standard, and those 6 factors are their knowledge is not common in the industry, so not specific to your company, just the industry in general, that their work has been beneficial to the competitiveness for the U.S. company and will continue to be in the U.S., that their foreign experience has been beneficial to their competitiveness both outside the U.S. and inside, that the specialized knowledge can only be gained with the employer, that the specialized knowledge is not easily taught and or acquired, or that the specialized knowledge is highly technical or complex and may or may not be related to your company, unique to your company. Those are the factors they listed in the memo. It's very helpful to kind of run down that list and say, how do you answer in each of these things? Does the employee fit all of them? And if the answer is no to all of them, it's not a good case. If it's yes to all of them, frankly, it still might not be a good case because you still need evidence to back it up. And letters from your company alone are not enough. Tangible evidence is key, and the more you can provide, as I said, emails where the person is being asked for their expertise, training where they are being trained, where they're training others to show that they have such a mastery, they're now running your training program. All of those items are helpful, and you're going to butt into the issue of not wanting to share proprietary inner workings of your company, work product, sensitive client materials. And again, I am very sympathetic to companies not wanting to release into the government items that are vital to their competitive edge. But then be prepared for an RFE or a denial. Again, the government basically says, if you don't want to play ball, you don't need this L visa. If you really need it, you'll give us what we want to hear, or give us the evidence that we're asking for. So I know that sounds very sort of bleak, but I say it because I think the L visa has become a catch-all where companies want to just use the L1 if they can't get an L1, if they can't get an H1B. And the reality is there's not that many employees that are L-1B specialized knowledge. They really do have to be exceptional. And if you have a workforce of, let's say, 100 in India, and you think there's 50 of them could qualify for an L-1B, 0 of them can qualify. If 50% of your workforce would qualify, they're not special. They're pretty average. So you have to remember it's a numbers game. It's also an evidentiary game. If you can't supply the evidence, you probably aren't going to get the visa. A final issue with L-1B. Previously, L-1Bs, again, were used as kind of a visa farm where consulting companies would bring over a lot of L-1B talent and then send them off to other companies. The government didn't like that very much. They felt like it didn't align with the purpose of the L-1B visa, and therefore, if your employee is going to be stationed at a client site, be prepared for a whole nother evidentiary standard where you have to show your company has, first, the right to control that employee and that the client site is not directing their work, your company is. And secondly, be prepared to show an agreement between yourself and the client, either an MSA, a job order, a statement of work, something, an end client letter that says the work of that person at the client site requires the specialized knowledge that they possess. And not that you just send all of your people to that site. That's not going to work. You need to have something that shows the specialized knowledge is required. And that's not to say cases don't slip through. There are cases sometimes that I'm even surprised were approved because, you know, if you don't have a company doesn't want to give me a lot of documentation, they want to take the risk. Sometimes those get approved. So, you know, you might think I'm being alarmist if you've had good luck with cases getting approved. Maybe that 25% of you are wondering if I know what I'm talking about. But there are some, especially in the IT industry where the USCIS has become increasingly suspicious of the use of L-1Bs, there's just a lot of pushback with whether or not it's a proper case. Well, now that I've alarmed everyone about their prospects with L-1Bs, I'll tell you what you can get if you're successful, which for L-1B is 5 years of validity. Again, a first application will be for 3 years, and then you'll be allowed for 1 2-year extension. You can switch from L-1B to L-1A. The person could come over, be in a specialized knowledge role, get promoted to being a manager, and they can switch to L-1A, and they will get that extra 2 years. The caveat is they need to apply for the L-1A at least 6 months before their L-1B expires. The rationale for that is the USCIS doesn't want people to apply for an L-1A merely to get another 2 years. It should be a planned transition where this person has proven their ability to manage and they are now a valuable manager for your company. So it's important to keep track of if the person's on a managerial track, you better bump them up to a manager before they're 6 months, they're almost 6 months to their max out date. Again, spouses can work for L-1A and L-1B, and intermittent applies to L-1B the same way it applies to L-1A. Someone can be intermittent, have to come in for special projects, do some work, goes back, comes back again. That's perfectly allowed. Opening a new office, if you do not have a current office in the U.S., you want to send someone over, you would need to be sending over a manager or an executive, someone who's going to be managing the growth and fostering the development of the company inside the United States. If you're a foreign company seeking to open a new office in the U.S., it really is a good option. It is, again, very document intensive. In the past, the L-1A new office standard was the company was just telling the United States government what they were going to do. Unfortunately, the USCIS now views it as tell us what you've already done to prepare for this visa, which can be costly for startup companies. For instance, they will require that the company has already secured a physical space that is sufficient for the growth you expect. So it's sort of a double whammy. You got to have the place, and it's got to be big enough, not just for that one person who's coming over, big enough to house a substantial amount of the people you want to hire. That can be very burdensome. You know, if you're trying to get an office open in Manhattan, even getting a desk somewhere is going to cost you a lot of money, let alone a bunch of desks that will remain empty until this person gets to the U.S. and can hire people for that role. So again, as an attorney, I'm extremely sympathetic to the cost that burden on a new company, but as your advocate, I have to tell people you need to get a space that's big enough. If you say to the U.S. government, we're going to hire 30 people in the next 6 months, and that's why we have to send over our VP of sales, well, you better have a pretty big office to hire 30 people. Otherwise, they're going to say you're not taking this seriously, you're not invested into the endeavor, etc. You will also need a detailed business plan with tangible goals. A big part of that is with an L1A new office, the first application will only be granted for 1 year. And that is because it is temporary and the USCIS expects to see progress made before they're willing to grant more time. So in that first year, the business plan needs to set out definable goals that are lofty enough to warrant someone coming over to the United States, but reasonable enough that when you apply for an extension in a year, you can say we've met some of them. So you don't want to say, we expect to hire 400 people if you really don't mean it. Because if you say you're going to hire 400 and you've hired 4, it's going to be difficult to get that extension to prove that this person has now the ability to support a new business in the U.S. So again, it's about managing expectations, about being detailed, providing numbers that can then be used later to get an extension. The U.S. government is a lot of lay people. They're not business people. So the business plan needs to be technical enough to show that you know what you're talking about and that you've really thought about what this new office will do, but plain language enough that someone at the USCIS who is by no means an expert in the opening of a new business to understand your plan and to say, yes, I see why you're sending this person to do these things. The employee for a new office also must meet the 1 year, 12-month continuous standard within the last 3 years. Usually it needs to be a little, they take it more seriously if the person's been there longer. For an L1A new office, my hypothesis, no one's ever told me this, but would be, of course, that when you send someone over who barely works for the company, it seems like you're not taking this new endeavor very seriously. So a lot of it is about perception on the part of the USCIS. Is when you have the evidence and a good business plan stating why you're going to do all these things, you have a good candidate who knows your company, or who has an impeccable credential. Someone could have only worked for your company for a year, but be perhaps, like Fixer, and their resume is filled with opening new businesses that are successful. That person's a great choice. But you need to have evidence as to why this person's a good choice and why your company's going to do this. Now, another poll. This is just asking if your company has an L blanket approval certification. If you don't know what those words mean, the answer is no, probably, hopefully. If you have it and you don't know it, you're doing yourself a disservice. So if you discover you have one, hopefully I will convince you to use it after this next slide. A blanket L is pre-approval of a corporate relationship. So I talked earlier about proving that the relationship between the entities, that they're parent subsidiary, affiliates, etc. With a blanket case, you're actually not submitting it at first for any particular employee. You're merely submitting corporate documentation saying, our company qualifies, and I will list the qualifications on the next slide. Our company qualifies, here's all of our entities, here's all the formation documents, here's all the stock certificates showing ownership. We want to get out of the way so that when we have an employee from, Visa Now India moving to Visa Now US, we don't need to provide any corporate documentation anymore. You will have already blanket approved us, and they will send you back a list of all the approved entities, and that makes your life a lot easier. There's also some other cool benefits that come with it I'll discuss in a moment. Suffice it to say, I highly recommend it. If your company qualifies for a blanket, please do it. It will save you time and money in the long run. It can be a process if you have a lot of entities, it might seem overwhelming to get a blanket approved. You don't have to do every entity. If you're a huge multinational organization with 150 individual entities, but you only really transfer people between 5, just submit for those 5. You don't have to do all of them. do the ones that are the best utility for you as a company. And there's always the option to amend later, to omit ones that are gone, to add ones that are new. But truly, if you qualify, it is really great, and you're about to see why. Although, Kristen, do you have our results?
I do. I knew everyone was on edge about that. So it sounds like a lot of you are going to want to listen to Karen. About 65% of you said no, and about 35% said yes. So hopefully Karen is going to convince you that this is the way to go.
For those of you that have one, I hope I'm preaching to the choir. I hope it has been much easier for you since achieving your L-blanket certification. For those of you who do not, first, how do you get it? Again, first you're going to have to amass the list of which entities that you want to have approved. Then you're going to need the documentation again of their formation and their relationship to the U.S. entity that is going to be the petitioner. There can be more than one U.S. entity. There just has to be one primary one listed. It could be the holding company. It could be whatever you want it to be. But you can include more than one U.S. entity. You can have them from multiple countries, one country. That's all up to you. You must establish, and I apologize, I'm reading the slide a little bit, which I usually don't like to do. You have to establish that you're engaged in commercial trade or services. That, again, could be financial statements showing that you are taking in an income, that you have sales, or you have redistribution, whatever you're doing, showing that the U.S. office has been operational for 1 year. Again, you could not wrap an L-1 ANU office and a blanket certification all in one. It wouldn't work. You wouldn't qualify for the blanket, but eventually you would be able to do it. And you have to prove there are 3 or more domestic and foreign branches, subsidiaries, and affiliates. So at least 3 entities, one of which has to be a U.S. that has been open for a year, and one which has to be a foreign entity that's been open for at least a year. Along with that, you have to have one of those 3 criteria at the bottom. 10 L-1 approvals within the last 12-month period, and if that's happening, you will probably run with open arms to get a blanket, because if you're doing 10 plus L-1s a year, that's a lot of paperwork that you could be reducing. Having combined sales of over at least 25 million, or a U.S. workforce of at least 1,000 employees. And that is or. You don't have to meet all 3 of those, just one will get you to L-blanket status. When you're submitting an L, you will be submitting the I-129 form plus a L supplement. It's very similar to applying for an employee, but you're just omitting that personal set of documents. It's just about the company. Initially, you're approved for 3 years, and then you're recertified indefinitely. So there is an initial period where you kind of have to prove yourself that these entities were not just opened for the purpose of getting a blanket, they aren't just like shells, and that your company really exists. And then after that trial period, you get recertified, and then it's indefinite. It will last forever. Of course, if your company ceases to meet the qualifications, you should cease to use it, but the USCIS doesn't have time to sort of go through and revoke them when they notice those things. So you could have a situation where your company has to be assessing if you still qualify, but for the most part, that's not a worry. People have much more than 3 entities. Like I said earlier, you can amend them repeatedly if you want to. You can add entities. You can remove ones that are no longer functional, etc. Once approved, what does it do? Why do I like these so much? The biggest one is you no longer have to send applications to the USCIS. Instead, you send your employees directly to a U.S. embassy or consulate, or if they're Canadian, you can send them directly to the U.S.-Canada border for adjudication. Adjudication is immediate. There's no waiting period. There's no paying for expedited processing. They make an appointment. They show up. They hand their package to the consular officer, and the consular officer has to read it and make a decision on the spot. The good news about that is they are more inclined to approve than deny for the most part. The officer is not going to have a ton of time to look through everything, so a lot of the success for a blanket, frankly, rests on the confidence of your employee. It's not a good time for them to be humble. They should go in there, if they're an L-1B, and be prepared to tell the consular officer how awesome they are. They're better than all their coworkers. They're the best. That's why they're sending me to the U.S. I always, in my prep calls for blanket cases, I tell people it's a job interview where ego is the most important qualification. Without being rude, of course, you would never want them to be rude, but it really is. If they go in nervous and they're like, well, I don't know, I'm not that special, they're probably going to get denied. Whereas if they can articulate what they do and why it's specialized, or articulate, yes, I'm a manager. I run a team of 5 people. They're moving me to the U.S. I'm going to run another team of 5 people. They should be well prepared, but very quick processing. Then they get the visa stamp and they come to the U.S. Again, don't have to worry about applying to the CIS or paying filing fees. You will only be paying the visa stamp fee, and there's a $500 fraud fee. The visa stamp fee varies, but fraud fee $500 does have to be paid. But that is heads and tail, heads above the filing fees that are going to be cost inside the United States, in addition to the waiting time. So you have a relatively lower bar in terms of evidentiary standard because consular officers don't have time. They don't have time to pour over every document. They're going to have to take a lot of it through your letter. And the confidence of an employee. And frankly, there are many companies who simply submit a letter and nothing else and rest on that without any evidence with a blanket. I don't recommend that because I think it jeopardizes it puts a lot of pressure on an employee to answer questions. I think they feel better when they have evidence with them, and you feel better knowing you've armed your employee for a good interview. But there are plenty of attorneys who do not ask people to bring any additional evidence to those besides the blanket approval and a letter. Like I said, I'm a bit conservative. I don't want people to get denied because the warning I will give is if someone goes to a consulate applying for a blanket L and is denied, they are never allowed to go apply for a blanket again. They can get L status, but they have to do it through the USCIS even though your company has a blanket. So kind of a harsh punishment if the person gets denied. Thus the reason I tend to say, hey, let's send some organizational charts along with them because that's worth to have them denied and remove that flexibility. So again, they're not going to have to bring corporate documentation. They already have that blanket approval in their hand, which has a list of companies. You can bring very little. You can bring much less evidence. I shouldn't say none, but in theory, you don't have to bring much at all. So faster time. Less wait time, you're not at the mercy of the USCIS processing, lower evidentiary standard, and it's the quickness is really what's kind of mind-boggling. Because that visa stamping process has to happen anyway. Even if you apply to the USCIS without a blanket, that employee still needs to go get their visa stamp, go to the interview, present everything to the person again. So you're eliminating a huge step and a huge cost. And a lot of companies are hesitant to provide so much corporate documentation up front because it seems to them like they're really showing their hand to the U.S. government. And again, I sympathize. But as an HR, if you have the ability to get people where they need to go faster, your lives are easier, managers are happy, employees are happier. So if I haven't told you enough, I don't know what else to tell you other than I'm an enthusiastic supporter of the blanket case if you do apply. So we're doing our last poll. I'm going to try and speed it up a little bit. The question is, have you gotten an RFE on an L case? So now that you know some general concepts, what does an actual petition look like? The petition itself is going to first have to have the documentation we've spoken about. Like I said, with the manager, you could have organizational charts, emails, reports, contracts, etc. L-1B, very fact-specific. It could be work product, training records, etc. But you do need to also have a detailed job description that shows the U.S. government that for a manager, they are mostly managing. So if you get a job description for a manager and half of their job is doing hands-on work, it's going to be very suspect. It needs to be manage the team of developers, review the work of others, not do work. So that's important to remember when you, as a company, are writing your job descriptions for managers as well. And don't forget to include corporate documentation unless you have a blanket, which hopefully you do after listening to me.
And Karen, just so you know, that poll was interesting also. 58% no RFE, 42% yes.
Okay. Fair. Maybe there's high numbers in not getting an RFE because all of you are here listening to L1 webinars, so you're already gold star HRs. But that's also relatively in line. Right now, about 30 to 40% of L cases get RFEs. So that is not terribly surprising. That's about the amount. It is far less for other visa types. It is astoundingly high for L cases. After you have your documentation, you're going to need to fill out the forms. The forms are the I-129 with the I-129L supplement. You should have a support letter in which you have clearly outlined your case, use specific examples of how the employee operates as a manager or a specialized knowledge. When I review a case, I kind of like to ask myself, would this convince someone on the street? If I handed them this packet and said, do you think this person's a manager? And they looked at it in a minute or two, did that convince them? And if the answer is no, or it's so confusing they wouldn't even know what you were talking about, you've done a poor job. And you need to think about it that way, because that's how CIS officers operate for the most part. They have a limited amount of time. They are not experts in your special field. They are just looking at them to get the gist and have you evidence that to them. So if it wouldn't convince someone on the street, it probably won't convince the CIS. Then mail it to the board of the government with the fee or appropriate fees, or any time you have a Canadian employee, they can apply at the border. Even if you don't have a blanket, if they're Canadian, they're exempt of visa stamps, so they can apply at the border. Can be very helpful if you have a lot of people in Canada. And then for blanket cases, you'd skip that step of applying to the United States government, and you would, I shouldn't say the government, to the CIS, you would be applying to the Department of State in their home country, or where they're authorized to live or work for their first one. They probably can go anywhere that will accept them for an extension of their blanket. I usually recommend their home country or where they're authorized to work or live. They generally have a more favorable adjudication there. At the consulate, like I said earlier, I alluded to this, it's important to coach employees to be confident, to be polite, treat it like a job interview. CIS officers, consular officers take their job seriously and want to be treated with respect. And so someone should show up in professional dress. They should speak professionally. They are, in a sense, interviewing for their professional job for permission to take that professional job. With a blanket, there will be probably a slightly longer interview because the person's actually deciding the case. If they've already been approved and they're just getting their visa stamp, it's a little more cursory to confirm the person is who they say they are and knows what they're talking about, but it's a lot shorter. Blankets tend to be a little more in-depth, but they're both relatively short, generally less than 15 minutes. And again, don't be humble. Your employees should be confident and know that they deserve this visa. And with that, we have some time for questions. Hopefully we've gotten some.
Yes, we have, and actually most of these you've answered.
Oh, good.
So I thought that we would reiterate some of them that you've answered since when they answered it. But this one I thought was interesting. So you laid out the qualifications for the blanket L. This person's asking, they really only fit that one of at least 25 million. Does that hinder the chance at all, or you just have to meet one of those? And
well, if you look at the slide, it's the bottom three that are the or. So it's 1,000 employees, 25 million, or 10L. If you only meet the 25 million one, that's fine, but you do need to meet the sort of above criteria, which are that you have to have those three entities. One of them has to be foreign. The U.S. office has to have been open for a year. Those are non-negotiable. Those you have to meet all of those. But then whether or not you meet the 10L, 25 million, or 1,000, if you just meet the 125 million, perfectly fine. Don't even bother, submitting how many employees you have. They don't care. So yes, you can just meet one of them as long as the other ones are also in place.
Perfect. We're getting some really specific ones that I think you're probably going to need a little bit more information on. So just know that we will have people reaching out here to everyone that attended to answer your specific questions. But another one that you've answered in the interim, but I just want you to reiterate because it was a little bit earlier on in the session, if we bring someone in on an L-1 visa, can we apply for a green card for him or her, or do we need to obtain an H-1B first to take advantage of the dual intent?
So L's are dual intent. So no, you can move straight from an L to a green card, and they can travel throughout the process. There's not going to be any concerns about their intent in entering the United States. L are dual intent. I will say there has been some interesting experience that myself and my colleagues at my firm have experienced recently, which is in blanket cases, we've seen a few improper denials for blanket L's where they claimed the employee did not show intent to leave the United States. We have gotten all of those reversed successfully because it's improper. They don't have to show intent to leave. That person could walk into their interview and say, I'm applying for an L-1B case. As soon as I land in Miami, they're filing a green card for me. That's permissible. There's nothing illegal about that. They could say it to the face of the consular officer. It appears there was a miscommunication somewhere in the Department of State. I don't know how it happened, but as a sort of example of inconsistency in the interplay between the Department of State, United States Citizenship and Immigration Services, the Customs and Border Patrol. With immigration, there's so many working parts. It can be very frustrating because what one branch of government says to an employee as they're traveling is different from what someone else said to them. And it's frustrating for immigration attorneys too, because it's difficult to have everyone on the same page in general in life. And when you're talking about branches of the United States government, even more difficult to get everyone on the same page. But suffice it to say, yes, dual intent is fine. That was my long roundabout attorney answer. Kristen, hopefully there's more questions. Save me for myself.
No, there's a lot of specific ones. I will say that we're getting some questions about other visas, which again, we will definitely reach out to you individually, but please, we will be doing a lot more of these webinars. We'll definitely take your comments here as to ones that we should consider. Here is one, and I think this might be our last one, and Karen, it's not a ton of details. I'm hoping that you will understand this. If not, again, we will reach out to this person to give a little more detail. Is L-1 transferable to another company H-1B or to other company H-1B?
Okay, I think I understand what you're saying. Yes. So transferring L from one L to another L would really only work if it's transferring from one entity in the U.S. that's owned by the same affiliates. So, if you were transferring from the Visa Now New York office to the Visa Now Miami office, and they were actually two different companies, but they're owned by, the whole Visa Now Holding Inc., that would be fine. I think what you're asking is, could you hire someone who's here on an L on an H-1B? And the answer is yes. So kind of could you poach an L candidate who's here and steal them away by filing an H for them? And the answer is yes, assuming they qualify for the H-1B visa and assuming that you get a spot in the H-1B cap lottery and then assuming that spot you got gets approved. So the domino effect of all the particularities of H-1B make it less of a likely scenario. But it is possible. You could switch status from L to H. And in fact, sometimes companies will do that internally. As I mentioned at the beginning of the webinar, because you can't use an I-140 to extend L's the way you can with an H-1B, if you have a candidate who moved from India, was born in India, moved to the U.S., you're doing a green card case for them, but they're on an L, it could take 9 years for them to get their green card. Their L is going to run out. And that's why people will often move from L to H-1B once they get to the U.S., because then you can keep extending that H-1B if you have an employee who's from a country where the green card line is very long. That can be very beneficial. And moving someone here on an L then gives you a couple cracks at getting into the H-1B lottery instead of keeping them abroad, waiting to get an H-1B spot. If they qualify for the L, you can get them here and then have a few shots at getting them H-1B approval and working on their green card as well.
Okay. any impact on dependents for that if you switch from the L to the H?
That's a great question, and yes, the big one will be the spouse will lose their work authorization unless the person has an approved I-140. The H-4 visa does not allow work authorization unless the H-1B holder has an approved I-140 or a perm that's been pending for more than 355 days. So that could be a real difficult decision for an employee to make. That if their spouse is working on an L2 work authorization card, to an H-1B could be a very big sacrifice for them. So something to keep in mind, people might be less inclined to do so unless you are also pursuing a green card that would provide work authorization for their spouse. But in terms of children, who qualifies for a dependent, can they study inside the United States, that remains consistent from L to H and vice versa. It is the work authorization that there is a caveat for the H-4.
Perfect. Thank you so much, Karen. I think we're going to end there. We want to be respectful of our time and Karen's time also. Like I said, a lot of very specific questions related to visa applications. While we ran out of time today, because we got so much great information from Karen, we will definitely have a Visa Now representative reach out to all of you in the coming days to discuss some of your more specific challenges. And thank you so much, Karen, for your time today. It was fantastic. And a big thank you to all of you out there for taking the time to learn about the L-1 visa and leveraging your organization's international talent. Thanks, everyone. Have a great rest of your week.